SJC-12383, Commonwealth versus Safali.
Mr. Sobelman, good morning.
Good morning, Your Honors. My name's Attorney Russell Sobelman, and I'm representing Mr. Lee, of course, and if it pleases the court.
If you could lift your voice a little bit.
If it pleases the court, may I begin?
Yes, you may.
Thank you. I'm going to start off with the major issue, which is the interpreter issue. I have 7 reasons that, including blatant insensitivity to a language problem, which resulted in the defendant being deprived of a fair trial. The trial judge concluded that the defendant knew to some extent English, which absolutely contradicts Attorney McGuire's affirmations on April 12th, 2016, when Attorney McGuire told the trial judge that Lee is in a very nervous state, baseline English is poor, he speaks English that's ungrammatical and has a very poor vocabulary and a low knowledge of the English language. And this is from Attorney McGuire, who the trial judge extols his reputation as one of the best defense attorneys in the county and in the Commonwealth of Massachusetts, and whose integrity is unquestioned. Yet the trial judge gave no credibility after saying this to Attorney McGuire's representations. I think part of the problem here, one of the big problems, is the trial judge could not let go of the fact that there were 23 hearings prior to trial without any complaints and interpreting issues, but he ignored information from Attorney McGuire and the interpreters who told him that Mr. Lee is an individual who, in their terms, quite polite, does not want to make waves, often does not say that he doesn't comprehend things, and when they can tell he doesn't actually comprehend them, even though he's saying he does, with the stress of the trial, he's been more forthcoming with his issues over the interpreting.
You have some very strong factual findings by the trial judge that you have to overcome, correct?
Yes, and I'm going to...
And it permeates throughout this trial where there's constant findings by the judge, and who's on the ground, listen to this, and can credit whoever he wants to credit. So how do you get around those?
Well, I think at the end of the trial, even after the trial's over on May 20th...
And maybe you want to go through your 7 reasons, and I interrupted you.
You did, but that's okay. I'll go back to them. I want to answer that question since you brought it up. I believe the judge had an open disdain for the defendant, and that may have prejudiced his rulings. And I'll give you one example of the prejudice the defendant was. The judge on May 20th, as you remember, made findings of fact after the trial was over. And the judge said, the only thing on the record which tells us he, meaning Mr. Lee, had trouble with the interpreters is one short affidavit. That was on May 20th, page 5. And you know, if you've read the transcripts, this cannot be further from the facts. The transcripts are replete with problems that the defendant had with interpreters, almost daily. But it doesn't stop there. There are flagrant inaccuracies as well on these May 20th findings, and I'll just highlight 2 of them. I'm not going to go over every one, but there are 2. On page 22, the trial judge states on the record, as a finding of fact...
Page 22 of May 20th?
Yes. Mr. Moy is registered in New York. Mr. Moy is registered in New York in Toyshanese for more than 30 years. We know absolutely that this is not accurate or true. Mr. Moy was registered in New York in Cantonese and Mandarin, not in Toyshanese. And then the second highlight I'll give you.
And so that was raised before the judge again? It was pointed out that that was inaccurate?
No, because this was after the trial. The judge on May 20th gave his findings of fact. Because he knew the interpreting was going to be an issue.
And I'm sorry, I should have written it down. What was that page reference?
May 20th, page 22.
Thank you.
Okay, and then on May 20th, pages 26 through 27, lines 23 through 1, that's May 20th, pages 26, 27, lines 23 through 1, and this is my second, actually, it's my third, but this is what the judge wrote. Each time the defendant requested a recess to talk to the interpreter, the court provided that time for the recess. Findings of fact, right? No, that's not true. The most important, by far, the most important request for a recess was denied by the court regarding a mere 45 minutes prior to the start of testimony by the Commonwealth's key witness. And
I'm sorry, before the start of testimony or before the start of cross-examination?
the judge wrote, each time the defendant requested a recess to talk to the interpreter, the court provided that time for the recess. And I'm saying that's inaccurate. The most important request for a recess was denied by the court regarding a mere 45 minutes prior to the start of cross-examine, actually, you're right, by the Commonwealth's key witness. And in fact, I'm going to tell you something. In April, I believe, yeah, this was on April 28th. On April 28th, pages 67 to 71, defense requested the court to recess for the day for approximately 45 minutes early in order to review questions written in Chinese by the defendant after the Commonwealth's key witness, they had one eyewitness, Mr. Lin, completed his direct examination, which the trial judge on the record estimated to be approximately 20% of Mr. Lin's trial testimony. So on April 28th, Mr. Lin, who had already testified a couple of days, he finished up on April 28th on his direct, and that direct on April 28th was 20% of his testimony, according to the judge. The defense counsel asked for a recess, which would have been 45 minutes early to let the jury go. The judge stated earlier in March, a month before this, in March, he said this to everyone: I think it is important that everyone involved in this case be comfortable that if things need to slow down, that they do. And if that includes if I'm moving too fast. Judge said that.
Well, but that doesn't mean that every request is granted.
Obviously, he has discretion, but he made a very important point. And if things need to slow down, that they do, and that includes if I'm moving too fast. The defendant only asked for a 45-minute adjournment, if you will, because this was the end of the day. With that, I respectfully suggest, and I know this is you're going to find this to be true, that 20% is a significant amount of testimony, and the defendant should have had the right to review his notes with his trial counsel. 40 to 45 minutes would not have made a significant difference in the trial management, and certainly could not have superseded the rights of the defendant.
No, the people, the person that testified against your client and the other people involved, they were all Chinese speakers as well, correct?
One was definitely a Chinese speaker, Mr. Lin,
Right.
but I believe some of the people were Chinese, but I think they were bilingual.
Okay. Amongst the group, did they speak amongst each other in Cantonese?
Which group?
Like Mr. Lin speaking to your client, did they speak Cantonese?
Mr. Lin, I believe, spoke
dialect.
Cantonese in, I'm going to say it wrong, Fujianese. He did not speak Toishanese. Mr. Lee, my client, he claims he had about a 90% understanding of Cantonese in conversation, that when he was around 17 years old in school, he learned Cantonese, and in conversation.
I'm just wondering if we can draw any inferences from the fact that outside of court, your client spoke Cantonese to his friends and.
I don't know about that. I know that one of the people that testified spoke some Cantonese, and I'm only guessing that they the only language they had in common was Cantonese, because Mr. Lin didn't speak Toshanese and Mr. Lee didn't speak Fujianese.
This issue of whether or not your client was gilding the lily about his Toshanese or ability to speak Cantonese, that didn't come out in context of his outside communications?
No,
Okay.
no, it did not. So, getting back to the insensitivity, Ms. Lowe, who again the trial judge praised, testified that Mr. Lowe had told her, "I don't understand." Ms. Lowe told the court that when Mr. Lee was asked if he understood, at first he would say yes, but then he would realize that he did not understand. She understood that he didn't understand, and upon trying to elaborate that to the judge when she was testifying, he struck her testimony as lay opinion. So she took the stand to see how well he was understanding. She tried to explain it to the judge, and he struck her testimony as lay opinion. So even after hearing information from Mr. McGuire, from the interpreters, that he was polite, he didn't want to make waves, it didn't matter. The judge said on the record that he didn't believe him, and that was that.
So, but we'll put that aside for a minute. Can we go to, before your time is up too much, the failure, your argument about a failure to provide a colloquy to the defendant waiving his right not to testify?
If you want.
I do, just briefly. I'm confused a little bit. I will just spend a second there. On page 69 of your brief, you're talking about Commonwealth versus Mitchell.
Right.
But this is about, and it says the preferable practice is a colloquy, but that's talking about the conflict of interest. So
Right.
what are you getting at here using that kind of cite for this point?
Well, I had down 6 reasons why I believe Mr. Lee, I have everything down, why Mr. Lee did not receive a fair trial. He had an unfair trial. And that's on my list, but it's just almost every trial I had over 30 years or more, the courts, I can't remember one time that a colloquy wasn't given to the defendant about whether or not he or she was going to testify.
Some defense attorneys don't want that, right?
I know, but at least I was asked. Sometimes I would say, but I can't remember it. Never asked.
Well, we've never required it, right?
No,
But you're asking us to
it's
do
just
it
part of the totality of the circumstances where, he had the interpreting issue where the judge sort of ignored the 23 prior hearings because he was polite.
Did you get through your list of 7, by the way?
No, I was on number 4, I think, but that's okay.
It's in your brief, right? All those reasons are in your brief.
I hope so. I may have added
But
some.
it's over 50 pages, I would hope so, too.
Before we leave the interpreter issue, let me ask a broader question. We've got a defendant who speaks either a dialect or a distinctly different language. By the way, do we know whether Taoshanese is a dialect of Cantonese or is a wholly separate language?
I think it's in the transcripts, but if not, I'll tell you what I've learned is all the language words, when they're written out, are all the same. It's the pronunciation and intonation that's different. And the judge pointed that out. There was a conversation about that, and it's a totally different language. It's Toshanese. I mean, people that speak Toshanese may speak other dialects of Chinese, but there's many languages throughout China, and it's based on the intonation and the pronunciation.
So just what is a judge to do when he has a defendant who speaks a language for which we have few, if any, interpreters? It appears to be relatively close to Cantonese, but is separate and distinct from Cantonese. And they're really, best I can tell, we don't have anybody who is qualified to interpret this particular language, perhaps because it's characterized as a dialect as opposed to a language, I don't know, but I expect we'll hear from that from Mr. Steinfeld. What's a judge supposed to do in these circumstances?
Well, Mr. Lee said there was one interpreter, Miss Lowe, who he could understand best. She, as you know from reading the case, she spoke Cantonese, but she was raised by her grandmother or great-grandmother, and her grandmother spoke Toshanese. So she understood Toshanese, and she could speak some Toshanese, and when there was a problem in Cantonese, she would then use some Toshanese, and this is all on April 12th. We learn about this in the transcript. And not only did Mr. Lee want Miss Lowe to interpret, and that would have solved this whole problem, even the day he was supposed to testify, or the day before he was supposed to testify, they told the judge, I don't trust this Mr. Moy. I don't really understand him all the time. I want Miss Lowe, if I'm going to testify, I want Miss Lowe to be my interpreter. Denied, denied. And the judge knew about all the problems he was having with the interpreter. We know that Mr. Moy was never certified or its equivalent in Taishanese anywhere at any time.
But your client raised an issue with Ms. Lowe, correct?
Excuse me?
The reason why we didn't have Ms. Lowe is because there was an issue raised with her, right?
I don't believe so. I think that's a mistake. I believe it was and I think the judge...
Because if everything was going fine, I would assume that there'd be nobody would say anything.
There were different interpreters. There was a Miss
Right.
L-I-U, Lou, and there was a Miss Lowe, L-O.
Once you settled on a good one, I assume...
Yeah, but for whatever reason, he wanted to keep Miss Lowe. The judge says Miss Lou, L-I-U, but no, it was Miss, and he dismissed Miss Lowe, even though it's on the record that Mr. Lee and the defense attorneys wanted to keep Miss Lowe.
What was the reason he gave to dismiss Ms. Lowe?
That we now have Mr. Moy. We now have Mr. Moy, who I scoured the record. There's nothing in there that he had ever interpreted Taiwanese at any trial.
Toshanese, but that was the, as I understood the record, Mr. Moy was brought in by the interpreter's offices to say, here's your Toshanese person. We finally found one.
Right, we found him. Here he is. And then the judge did a colloquy of him. But he was never certified. He never took a written exam. He never took an oral exam in Toshanese. And there's no evidence of his ability to interpret at a trial. And I have the date. On April 14th, Mr. Lee stated he would accept Miss Lowe, but the trial judge rejected this request.
Would you agree that you characterize the trial judge as just basically saying, I don't believe Mr. Lee. I think he was just doing this because he didn't want to go forward, and he's trying to frustrate the trial, and he's frankly lying about his inability to speak Cantonese?
Yeah, that's pretty clear from the trial, and the judge thought it was gamesmanship. But if he allowed Miss Lowe, we would.
Well, but what?
This wouldn't be an issue.
True, but, well, something else might, but what about him making credibility findings? I mean, he's there, he's watching everything. Why is he not entitled to form a judgment and articulate what it is? It's not like he withheld it from anybody.
No, and that's what he did on May 20th. And as you can clearly see, I just gave 3 examples. In his findings on May 20th, 3 of them are totally inaccurate. Only one short affidavit saying there was a problem with the interpreters, that Mr. Moy is registered in New York in Toshanese for more than 30 years, about each time the defendant requested a recess to talk to the interpreter, the court provided that time. You can, obviously, his findings of fact are not accurate, and I think his open disdain for the defendant is throughout the trial. He just ignores the attorney, Mr. McGuire, the interpreters who tell him the situation. And he's entitled to the, there was a new case that just came out on Friday, Cologne, last Friday, Cologne. And in that case, trying to find it here, because it's, oh, here it is. There's a footnote in the recently decided Cologne case on May 3rd that said, the court noted it's a judge's duty to aid, not hamper, a criminal defendant in understanding what is occurring at the defendant's own trial. And I think that's what happened here. Judge early on did not believe Mr. Lee at all, and that permeated throughout the trial despite what people with a lot of integrity were telling the judge. And even on his own findings on May 20th, he sort of forgot those things.
Okay. Before we let you go,
Yeah.
Mr. Moy, I gather you say was not certified
No, he was not.
in Taushenese. Was Ms. Lowe certified in Taushenese?
No.
So it's, you can't say Moy was the wrong person because he's not certified in Taushenese and then say that he wanted Lowe even though she's not certified in Taushenese.
Except the defendant, I think, has the right to voluntarily, based on a colloquy with the judge, dismiss the interpreter and have somebody, and he would have, and Mr. Lee would have accepted Miss Lowe's Cantonese with a little Taushenese. Mr. Moy did not speak the Taushenese that Mr. Lee spoke. It was a different type. As you can see, there was an old-fashioned Taushenese from the 30s and the 40s, and then there's a new one. Miss Lowe knew the newer version, if you will.
So what is, you're saying the judge abused his discretion, I gather, correct?
Very much.
And so what is the standard, because this idea, not this idea, but it's not that unusual for a defendant to say this interpreter does not speak the same Spanish or other language that I speak. You know, this is Ecuadorian Spanish and I'm Mexican. It's not unusual for a judge to hear that the interpreter speaks a different type of language than the defendant does, and I'm having some trouble in understanding each other. That's not unusual. What's the standard for what a judge is to do to avoid an abuse of discretion?
Well, I'll answer that, but I want to add one small detail, and that is, in this case, even the interpreter told the judge that he didn't understand everything that was being interpreted. And it was also, Mr. McGuire also stated that. So the judge then, in this case, the judge had discretion to say, okay, if you want Miss Lowe, I will allow that, and we'll have Mr. Moy as the backup or relieve his responsibilities.
It's an abuse of discretion to not say, I will let you choose which interpreter you feel most comfortable with?
I would say yes in this case.
Okay. Thank you.
Okay.
Mr. Steinfeld.
May it please the court, Kenneth Steinfeld for the Commonwealth. The main issue here, obviously, is the interpreters. And there's one overarching question that I think resolves all of the rest. And the sole question really presented is whether Judge Lowy's determination that the defendant understood Cantonese and was aware of what was going on and was fully able to comprehend the proceedings and to talk about them with his lawyer and to help his lawyers prepare for cross-examination, whether that determination was supported by the record. I think that the question is absolutely yes. And like my brother, I have 4 principal reasons that I would like to.
He has 7. He has 7. You only have 4?
Maybe next time I'll have 8.
Okay.
But here, 4 main ones. Judge Lowy, if I were to list all of the bases for his determination, it would be way more than 7. But I want to focus on 4 that he focused on both during the trial and also at that very, very important May 20 finding. That is post-conviction, post-sentence. He laid out at extraordinary and detailed length why he thought that the defendant understood what was going on. He summarized his findings. First, there was the pretrial proceedings. 5 years, no objections, a whole bunch of pretrial proceedings. 7 days of jury impanelment at the first trial, 3 days of jury impanelment at the second trial without a peep. Motion after motion after pretrial motion seeking funds for a Cantonese interpreter. No objection to it. 60 visits with his lawyer prior to trial, 50 of them with a Cantonese interpreter. No complaint. Second, I think it's very important, the judge focused also, when the defendant first complained about his incomprehension was right after the jury were sworn. The first court day after that. There were 3 days of jury selection, March 8, 9, and 10. Tuesday, Wednesday, Thursday. The following Monday, defense counsel said that his he said that his client had problems with jury empanelment. And so they met again 2 days later on May 16th, and defense counsel told the judge, my client no longer has any problem with the jury selection. He has made clear to us that he fully understood it. And so the trial judge very diligently and very conscientiously held a full colloquy with the defendant to establish that his waiver of his right to object to jury selection was knowing and voluntary. And in that colloquy, the defendant said explicitly, I speak Cantonese. And he made clear that he fully understood every single question that the judge asked him during that colloquy. And Judge Lowy even noted in his findings on May 20 that a lot of those questions were complex and he had no problems answering. The third major basis is on the 12th of April, the defense counsel asked the judge to inquire of the two interpreters, Ms. Lowe and Ms. Liu, about their interactions with the defendant. And they did so testify. And they testified that in their view, the defendant understood them and they had no problems not understanding him. The defendant said at that time that Ms. Liu was making things up. And Judge Lowy properly found, or could have found and did, that he credited Ms. Liu when she said she was not making things up, and that the defendant's claim that she was further evidence that he was not being truthful when he said that he did not understand these Cantonese interpreters. Fourth, Judge Lowy went to extraordinary lengths during his May 20 findings to talk about the juxtaposition between the defendant's testimony on direct and on cross. He went over each of the 625 questions asked on direct and the more than 300 questions asked on cross. And he gave example after example after example, and he could have gone on about, he had no problem on direct answering all of the questions. And whenever he was asked a question on cross that did not inculpate him, he could answer. But as soon as anything touched on some issue that could harm him, he said he didn't understand. If he asked to repeat it, he would give a non-responsive answer. And so those four reasons, at the very least, provided Judge Lowy with a valid basis to conclude.
Let me ask you this. So if we have all this evidence, in at least the first two you talked about, where the judge finds that he does speak and he says he speaks Cantonese.
Yes.
Why switch to Toishanese if he's just lying?
Well, because out of fairness, he went to great lengths. He said, instead of just resting on his laurels and say, well, I don't believe you when you say you don't speak Cantonese, so I'm going to force you to have a Cantonese interpreter the whole time. He said, okay, because you keep insisting that you want a Taishanese interpreter, I will go even farther and work with OCIS to find a Taishanese interpreter to satisfy your continued demands, even though I don't believe you. So they found Wei Moy, who came in, who spoke Taishanese, had outstanding credentials. I do admit he was not certified in the state of New York, and when Judge Lowy said on May 20 that he was incorrect. However, he had 31 years of translating in courts in New York, and his qualifications to translate were absolutely solid. But it is true.
Translate in Cantonese, Mandarin, and Toishanese, or just?
He was certified in New York in Mandarin and Cantonese, but not in Taishanese.
But his experience in New York wasn't exclusively in Toishanese, right?
That's right, but he had been translating Taishanese among those other languages for 31 years at the time, 1985 to 2016. So Judge Lowy had a solid basis to determine that he was qualified.
And his credentials will be in the record.
Oh yeah, they're all there. And there's also a colloquy of him where he talks about it. He was a foreign affairs officer for the U.S. Marines and had just incredible experience. So there's no doubt that he spoke Tajinese, but it was in fact Judge Lowy's desire to go even further than he had to. That's why he provided him a Tajinese interpreter. So then when the defendant comes around and complains, okay, you've gotten me this Tajinese interpreter that I've been begging for, well, he's no good either because he speaks old-fashioned Tajinese that I can't understand a word of. He uses words from the 20s and 30s, and oh, I want Ms. Lowe back. Now, Judge Lowy made a finding that the defense had objected to all Cantonese interpreters, including Ms. Lowe, who was a Cantonese interpreter. And that finding is supported by the record. He did ask for Ms. Lowe a lot, but at some point, his counsel said, we object to Cantonese interpreters. And Judge Lowy was very, very plain on the record, and it's cited in my brief. He says, I find that you are objecting to Ms. Lowe as well, period. So that's in the record, and that is supported by the record.
But he didn't want to go back to Cantonese because the defendant had said there was an issue.
Well, he found that that was further evidence that he understood both Cantonese and Tajinese. I would add that for purposes of this case, the Commonwealth does not dispute that for all intents and purposes, Cantonese and Tajinese are separate languages. The fact that a person can speak one does not mean that that person may also speak the other.
Was there anything made of the issue that there were a bunch of people involved in this enterprise? They all spoke some type of Chinese or Chinese dialect, and it was probably Cantonese?
There was testimony about that, but the judge did not take that into consideration. But I can tell you that Lin testified that he spoke Mandarin, Cantonese, and Fujianese. And Lin testified that he spoke to the defendant in Cantonese and sometimes in Mandarin. Lin spoke to Sun in Mandarin and Fujianese. So that was the testimony from Lin, that when he spoke to the defendant, it was in Cantonese. And Judge Lowy never relied on that, but that's in the record, and certainly under 33E, this court could take into account the fact that there was evidence that the jury clearly credited that he had a lot of communication because Lin did not speak Tajinese. So that is in the record, but the judge did not actually rely on it. There are three phrases that my brother used that I would like to object to: blatant insensitivity, open derision, and prejudice against the defendant. I think those are not fair characterizations of Judge Lowy's attitude toward the defendant. He merely had to repeatedly say the same thing over and over because he continued to feel that way, and the defendant, as was his right, made objection after objection after objection. And so Judge Lowy was merely repeating what he had already found, and he had and each time there was an objection, there had been further evidence since then showing that the defendant fully understood. So all that Judge Lowy was doing was providing more explanations. And I won't say he did not get frustrated, he did not get upset. He dealt with every single one of them. And the fact that he used strong language does not indicate that he was blatantly insensitive or that he had open disdain or that he was prejudiced against the defendant. I don't think the record bears those comments out at all. The judge never relied on the notion that the defendant spoke English. He does mention during his closing there was indications that he spoke English, and in fact, the defendant answered some of his questions while he testified in English. But Judge Lowy did not say, because you speak English, I find that. So we are solely talking about his ability to understand first Cantonese through the interpreters and then the Tajinese interpretation by Wei Moy. I'd like to talk about the 45-minute issue, if I may. What happened was the major witness against the defendant was clearly Jun D. Lin, who was the cab driver. And so he testified on direct over 3 days, April 14, April 15, and then for part of the day, 13 days later on the 28th. So the bulk of his testimony was on the 14th and 15th, and then there was a 13-day break for school vacation, plus the juror was ill. So they didn't reconvene from the 15th until the 28th, when the Commonwealth finished its examination of Lynn, and there were 45 minutes left in the day. And the defense counsel did not ask for a recess. He asked for his cross-examination to be postponed 4 days until the following Monday. And Judge Lowy said, well, we have 45 minutes. You know, you should be able to cross-examine him for 45 minutes. You've had what he characterized as 80% of his testimony. You've had that for 13 days. You've had time to go over that with Mr. Moy. Mr. Moy made himself available to the defendant and counsel on the 2 days prior to the start of cross. So when Judge Lowy says you can do 45 minutes and then come back next week and do the rest of it, that was an absolutely proper exercise of his discretion to manage the witnesses at trial. So when Judge Lowy said, I never denied a recess for time for the defense lawyer to talk, he was absolutely correct. This was not a request for a recess. This was a request for a postponement. And sure enough, defense counsel did 45 minutes of basic cross-examination, and then he had a whole full day the following week to do the bulk of his cross-examination. And so the idea that the defendant was prejudiced because he didn't get this because he had to start and do 45 minutes of cross that day, in no way prejudiced him, and was an absolutely proper exercise of the judge's discretion, as I said.
So how long was the total cross?
It was all of the following court day.
So which was it?
I believe most of the following court day.
May 1st or May 2nd?
Pardon me?
May 1st or May 2nd?
Yeah, the first court day after.
Monday. It was the Monday or
28th. Yes, it
probably,
was that
yeah.
following. It was a Thursday to a Monday.
Okay.
And so that's why defense counsel didn't ask for recess. He said, I want to, not do anything today, not do anything tomorrow, have it on Monday instead. And so for the judge to say, no, do 45 minutes across, there's no prejudice from it, and it was, perfectly reasonable thing for him to do. I believe that I have said I do want to add one thing. The defendant does argue in his brief that 221C, Section 91, which provides for the appointment of certified and qualified interpreters, superseded 22192 and Mass Rule of Criminal Procedure 41, which provide generally for the appointment of interpreters as the justices of the court may find necessary. And I just want to note that there's a very strong presumption against a statutory implied repeal of prior statutes. And the fact that Wei Moy was not certified or qualified under 221C91 does not mean that the judge did not have the power to appoint him under 22192 and Rule 41. Because if that were the case, that if 221C91 superseded the earlier ones, that means that anytime you had a defendant who did not speak a language for which OCIS had a certified or a qualified interpreter, then there'd automatically be a statutory violation. And I think the court could take notice that there are thousands of spoken languages in the world, and according to OCIS's website, which I know is not part of the evidence, I think they have 160 languages or so. So it is entirely possible, and that's why Rule 41 and the statute 22192 exist for situations in which you have a language that a defendant speaks for which OCS does not have anyone who is on its list of screened and certified interpreters.
Does the record indicate whether there is anyone who is certified to interpret in Taotianese?
Yes. There was a man named Gar Chang, I spelled Garrrching, who was discussed early in the trial. He had recused himself prior to trial because he said that he had a business conflict of interest with a lawyer for John D. Lin, and then there was later talk at trial about having Gar Chang come in and do Taotianese, but the defendant strongly objected because he believed that Chang was prejudiced against him and his family. So there is one person, according to the record, who was certified to speak Taiwanese, but he didn't want to, and the defendant didn't want him. So they did not ultimately bring him in. But the answer to that question is yes, there was one person, Gar Chang, who did not ultimately make any appearance at the trial as an interpreter. I'd be happy to discuss any of the other issues or to answer any further questions on the interpreter issue. Otherwise, I'd be happy to rest on my brief.
Okay, thank